All right, we're going to go back on the record. I want to note for the record that I have received via email a subpoena request from Mr. Cluck. I have showed a copy of the subpoena request to Mr. Gallagher. We will post the subpoena request on the website so that everyone can see it, and then any argument on it will occur, and a decision by the board will occur at the next meeting or the next conditional use hearing. Do you have any further witnesses, Mr. Gallagher? You would rest your rebuttal case at this point in time. Okay. I know, Mr. Cluck, that we had talked about a possible rebuttal case.
Depends on these three documents.
Okay. So what I'd like to do, I'll hold your request for a rebuttal in abeyance at this point. What I'd like to do is see if there is any, we can at least start public comment. Public comment is designed for those individuals who are not parties to the case or are not represented by counsel, and is subject to the township's ordinance that your time will be limited to 5 minutes. Are there any members of the public who wish to address the board on this application? No, it is not. This is public comment for non-parties. Okay. I'm seeing no response from the public. So again, is there anyone from the public who is not a party who wishes to address the board on this application? Let the record reflect that there has been no response. So at this point, the next step in the process would normally be closing argument. We're not going to start those tonight because I want counsel and parties to have an opportunity to prepare their closing arguments. That said, Mr. Cluck, I understand that you want to reserve the right for a rebuttal. What would be would your rebuttal be limited to the issues regarding this evening's testimony?
The draft December document is relevant. If I have rebuttal, it would be with respect to the bird issues, whether it's Dr. Goodrich or someone else. There's a possibility once they see the transcript, we may or may not want to rebut. And obviously, if Davey has something of relevance, we'll have to, maybe we'll address it. Maybe I don't know until I see it. The same goes for the updated wetland study.
Okay. Mr. Gallagher.
I don't even know that there is an updated wetland study. Or there's a typo. I don't know, but again, I would also say that it is entirely irrelevant to this conditional use decision. These studies aren't even relevant to maybe land development, but also DEP permitting that happens after a conditional use hearing. So everything that he's asking for is not real relevant to this board's consideration of the application.
I would then request that the applicant strike and withdraw the wetland delineation exhibit, the stormwater management exhibit number 32, all of the testimony from Mr. Hughes with respect to wetlands, bog turtles, the PNDI exhibits, and everything that's not related to conditional use on all the various studies and topics for which they spent multiple hearings having a witness. If these aren't relevant, then strike all those exhibits and testimony for the record.
We're not going to do that, Mr. Cluck. But I understand your argument. I'm trying to, from more of an administrative point of view, we're going to have we're going to come back. The next hearing is going to be on July 11th. And that's going to be, it's not going to be in this room. It's going to be at the Township Building. That's at 110 Haas Road in Windsor Township. So again, it will be at the Township Building, not at the school. And from an administrative perspective, I am trying to determine, I don't want to waste the evening, but we can't start closing argument unless you have completed your case.
Did we decide argument before proposed findings?
We had, yes, but so, but I'm debating whether or not I want to change that. So, and then the applicant had indicated that he'd be willing to potentially grant additional time to the board to prepare the written decision. How much time do you gentlemen and any of the other parties want for findings of fact and conclusions of law?
Well, as I mentioned last time, it would be nice to close the hearing, right?
Yeah, right.
That it's our
Right. We have to close the record.
yes, and it's going to take more time than 45 days. So we are agreeable to extension. I'd like to know what the record's going to be, but we will be extension beyond 45 days.
Okay. I guess what I'm contemplating at this point is that we're going to come back on July 11th for argument on the subpoena. Now, Mr. Gallagher, there were 3 items on the subpoena. Are you willing to produce the second and the third item, which are one was the bog turtle report and...
Yeah, I mean, I believe so. I would like to be able to review it. I haven't even served with a subpoena, and you just showed me an email, so I'd like to be able to review it, but I do not see any issues. And as I mentioned with wetland delineation, I'm not sure what the difference is, or if there is even a difference.
And I guess what I'm trying to determine here is, Mr. Cluck, if he will produce items 2 and 3, would you still require item 1? Because I do think there are potential privilege issues with item 1.
If he does 2 and 3, I don't need 1. I'll compromise.
So my point is we can avoid the issue of the subpoena if you'll agree to 2 and 3. And I'm not. And what I would request, Mr. Gallagher, is if you could provide within the next 10 days a response to whether, because I understand that you need to review those documents, and I don't want to make you commit to it, but if you could, by 10 days would be the 16th, which is a Sunday. If you could provide a written email to myself and all parties indicating whether or not you will agree to provide those items by June 17th.
Yeah, and that's fine. That week, June 17th, I believe, is Monday.
That is a Monday.
You have another hearing on Monday, so...
You don't have to come here. I'm just listening.
You have to that should not be an issue, but I would like to understand, just what is the relevance of that? So we did taking it to a logical conclusion, we did a study that satisfied Fish and Wildlife. I mean, what are you going to present that we have appropriately addressed the bog turtle? So we're not going to present any further witnesses. What are you trying to establish or prove? Wetland delineation is wetland delineation.
Then why did they change it? You haven't seen it, so you can't answer.
I don't even know that it has been changed, but assuming that it's just a regular update.
What's a regular update on a document submitted into evidence for conditional use? It is or it isn't.
Okay.
It's not a moving target.
I don't know that there is a different one, and I don't know what the standing here. I'm not going to have this debate about it, but I'm just saying that if it's substantially similar to the one that's already been submitted, what's the point of additional testimony on it?
Nothing. If it's merely adding a new date on the cover sheet, then there is no difference.
And as I'm said, sitting here today, I don't know. We'll take it under advisement. But I'm just saying, like, if we do present it, I don't see the point or relevance to it because it's, okay, yes, we provided it. Much like the economic impact study. You requested it, you provided it, okay, I don't care about it. I don't want to go through that exercise on July 11th when we can just jump into closing arguments.
And I tend to agree, Mr. Gallagher, which is why my hope is that by June 17th, that you can tell us that you can provide, whether or not you can provide these, because then we can avoid the issue of the subpoena. My expectation would be, Mr. Cluck, that within 10 days of receiving those documents, that you can make a determination as to whether or not you're going to require Sir rebuttal, because I would like to get into closing arguments.
Okay, so it's still, assuming I get a transcript from tonight in a reasonable time, and the Hawk Mountain people get to review it and decide there's nothing worth responding to, you want to have argument on the 11th.
That is correct.
And then a period of time to propose findings.
Yes, that's what we're going to do.
Okay. Do we have you would ask Mr. Gallagher how long he wanted to propose.
Well, I'm trying to understand, because as Mr. Gallagher pointed out, this is not his only client. I'm sure it's not your only client, Mr. Cluck. I'd like to get a reasonable sense from you as to how long you think you're going to need to prepare findings of fact and conclusions of law.
As of this moment, I have a major trial, July 22, for which I am drafting a motion for continuance to be filed in the morning. If it's not continued, I'm on trial for a full week, third week of July. So I'm going to need at least 30 days from July 11 for proposed findings.
Okay. And what do you think, Mr. Gallagher?
I don't know. I'd like to get, that we haven't even determined whether or not July 11th is actually going to be the date.
I'm not asking for from July 11th. I'm just asking generally, are you looking for 30 days, 60 days, 45 days?
Me, no, not that much time. And I have to consult with the client and get approval because it's on me to get it done whenever they need to get it done. And that, under the state statute, I appreciate when you can work with Mr. Clark, and I don't know that they're going to agree with 30 days. That's what I'm saying. That decision is only on us. We can grant that time frame is what we want. But we are willing to grant time beyond July 11th. What that is, I don't know.
Well, I don't think we're going to conclude closing arguments on July 11th because it's not just you two gentlemen, but it's all the other parties who have entered their appearance have the opportunity to present closing arguments. So I'm trying to get a general sense of how long you'd like, and I'm hearing 30 days, and I'm hearing something less than 30 days.
It's not going to be more than 30 days.
Okay. I don't think 30 days is an unreasonable period of time to request. So what my, so what I would suggest is that when we close the record, we're going to provide 30 days to provide findings of fact and conclusions of law. And it's my anticipation that we're going to close the record on July 11th. So, I think we can have that proceeding as we're doing closing, that timeline proceeding as we're doing closing argument. So, assuming we close the record on July 11th, then that will mean that that findings of fact and conclusions of law will be due on or about August 11th. And I would request that and you can send me a written confirmation that the township will receive an additional 30 days beyond the 45 days. So if you can send me a written letter. I don't know if you need to discuss that with your client.
I would like to discuss it,
Yeah.
but I mean, we can do it next year.
Yeah, right. But this way, everyone is all the parties are on notice that we're looking at findings of facts and conclusions of law being due 30 days from the close of the record, which we are projecting will be July 11th, and so then they will be due. Just want to make sure that's not a weekend. Of course, it's a Sunday.
Well, I mean,
Yeah. So findings of fact and conclusions of law will be due by 5:00 p.m. on August 12th. And they can be submitted via email to myself, copied to all parties of record. And we will proceed. We're proceeding on July 11th and July 17th, both at the Township Building, for closing statements, closing arguments, and potentially a SIR rebuttal case if there is one on July 11th. Do any of the parties have questions about this?
Yeah, let's do this second. Finding the law. Do you need transcripts to do that?
If you want transcripts, I'm sure that this wonderful young lady up here will be happy to provide them for you. They do come at a cost, but the transcripts can be made available.
They can't be put on the website of the shared documents like anything else?
The exhibits can be, the transcripts cannot.
But are they vital to doing these findings of law? Can you do it without it?
I can't answer that question. Because if I answer that question, I'm giving you legal advice. And I'm not permitted to do that. Does anyone else have any questions about the timeline? Yes?
If we need the July 17th date, would the 30 days start after that? Or no?
So if we need the July 17th date only for closing argument, then no. Because as long as the closing argument is not really part of the record so much as it's just argument on how you want the board to rule. So there's no new facts or evidence being placed into the record at that point. Okay.
Is there a time set for closing argument?
We're starting on July 11th.
No, the amount of time someone can speak.
No, there is no time limit.
You accepted public comment tonight, that's it? If people show up July 11th who weren't here tonight, who are not parties but are members of the public.
I'm going to ask again on July 11th for public comment. Just in case there are other members of the public who would have been here had they known that there would be public comment. Okay. I think at this point, Mr. Chairman, you can entertain a motion to adjourn until July 11th at 6 o'clock p.m. at the Windsor Township building located at 110 Haas Road, Windsor Township, Berks County, Pennsylvania.
Okay, would someone make that motion? Do I have a second? All in favor say aye. Aye. Ayes have it.